Hi, here at Fazio Law Offices we help people who want to present a defense to their foreclosure. So we wanted to go over what the basic defenses to foreclosure are to give you just a little bit of an idea from a 10,000 foot view of what you can do when you're served with a foreclosure complaint. There's three main defenses, which are predatory lending, lack of standing, and the Consumer Fraud Act. Now, when we talk about predatory lending, we're talking about a loan that was made that could never be paid back. A lot of people have loans that maybe weren't the best possible loan that they could have gotten, and then they want to attribute the blame for that to the bank. But if you have a loan, for instance, where the payments are $5,000 a month and you're only making $3,000 a month, chances are that might be an instance of predatory lending. The second big defense is lack of standing. The banks sell these loans that are not performing around like hot potatoes rather than helping people to put them into good standing and get them on a track where they can keep their home and repay their loan. Because of that, sometimes there's problems with the standing that the bank has to bring the foreclosure action into court. This might happen when it's been assigned several times, or when there's missing documentation such as the original note or some of the underlying transfer documents. How does this help you? Well, if you have a lack of standing defense in a foreclosure action, it might also mean that you're having trouble getting the bank to deal with you and give you a modification because the people who would have the authority to give you a modification are not available and aren't able to weigh in on the process the way they would if the bank had all of their standing in order. Lastly is the Consumer Fraud Act. So there might be circumstances where either in the modification process or earlier in the loan process, the bank did something fraudulent. A common example that people can remember is when Wells Fargo had these extra accounts for people. In the foreclosure situation, a lot of times it's when they took advantage of like reverse redlining and went after a population of people that were, had lower credit scores. Like this happened in Irvington and in the Newark area. So there's different instances where the banks have actually targeted or done something willful and intentional to try to get more money out of certain groups of people. If you have this kind of defense, you have to raise it within 6 years. So if you had a 2006 or 2007 loan, it could be too late. And I want to talk about the little three or the other three defenses, which are also very important. These are modification fraud, equitable tolling, and the statute of limitations. Modification fraud is simply when the bank tells you they're going to review you and then they don't. A lot of people call multiple times. They hear different things from different people. They're asked to sign the 4506T document over and over again. Ultimately, they're given the runaround. Or the bank knows that you've got a lot of equity in your property and they sit on their hands and don't take any action for a prolonged period of time, which then gives you a claim to toll the interest or roll back the interest that they've unfairly accrued at your expense. And finally, the statute of limitations. Justice delayed is justice denied, and it's been said that a suitor in equity must come to court with clean hands. So if you're dealing with a bank that's taken more than 6 years, now that's not the statute of limitations in New Jersey, but just as a general rule, if they've taken more than 6 years to take any action, you might want to look into whether you have a statute of limitations defense, although this comes up most commonly with commercial or private loans and not with the traditional bank loan you get to buy your property. So I hope that helps to understand the big three and the little three of foreclosure defenses in New Jersey. Thank you.